जनाब राना आसिफ साहब एक्स मेंबर पंजाब बार एक्स प्रेसिडेंट हाई कोर्ट से रिक्वेस्ट करता हूँ कि डाइस पे तशरीफ़ लाएं और जो मौजू है हमारा उस पर लेक्चर दे। लॉ ऑफ रिट के हवाले से है मौजू। जनाब राना आसिफ साहब।
In the beginning, the vote of thanks to the Executive Committee of the District Bar Association Multan, especially to the Chairman, Legal Education Committee, Janaab Iftikhar Qureshi, the Vice President. And with this vote of thanks, in the beginning there is also a notification of the disclaimer that though I am here to share with all my colleagues my little bit knowledge about the law of writ, yet I believe that me at least cannot claim that perfect and the conclusive knowledge on the subject. We all live to learn, and I myself believe to be a student of law. Therefore, whatever I'll be sharing, that may be subject to correction, may be subject to finalization about the latest views and about the latest expression on the subject. As I have been asked to share my views with regard to the law of the writs, so before I ponder over on the law of the writ, it is imperative to have a background of the various kinds of the legal remedies, and it is very primary aspect to have a background of the legal system of a state, that what kind of remedies a legal system of a state provides against the wrongs. So to run the affairs of the state, an anchor sheet, which is the constitution of the state, is a piece of, that is in the English law, that is known as the Bible, that is to how the affairs of the state would run, that is provided under the constitution of any state, and how the legal remedies to the citizen of the state, and how the various affairs of the state, different departments of the state, and how the executive of the state and how the legislative of the state would work. A framework is always provided under the constitution in almost all the democratic states. And so far as our country, which is Islamic Republic of Pakistan, this is being run under the constitution known as the Constitution of Islamic Republic of Pakistan of 1973. Different tiers of legal system have been provided, different forums have been provided for the remedies for the citizens. There are two kind of remedies. One is under the regulatory regime, like the different departments of the state, say law and order, say providing the legal, providing the education system, providing the health facilities, providing the communication system. So that the government departments are run on each department's own regulatory regime, like the municipal services, like law and order. With regard to the law and order, mainly the offences and the penalties are provided under Pakistan Penal Code, and for the purpose of the trial, the Code of Criminal Procedure is there, and there are so many other penal laws, including Pakistan Penal Code. So that is the with regard to the law and order law. And when we speak of municipal services, suppose, so then we can see the local government ordinance. When we see the labor laws, there is a labor law, Industrial Relation Act of 2012, and likewise there are so many regulatory laws framed under the constitution to run the affairs of the state, and under those relevant statute of the departments of the fields, there are remedies for the wrongs. And if someone feels aggrieved, say I quote here the municipal law, like someone is aggrieved of the conduct of the municipal functionaries, either with regard to the provision of some municipal service or with regard to some of the facilities by the municipal service. So one has the right to voice his grievance against the concerned field worker to the chief officer of the municipal corporation, and if someone is aggrieved of the order of the chief officer of the municipal corporation, he may have the resort to approach to the administrator when there is no elected government, and in the eventuality when there is an elected government, to the mayor. And so there is a scheme of law in all departments where the remedies have been provided. But the question arises that how comes the writ figures, how come the writ come into play, and how come the necessity of availing the remedy under the writ is felt appropriate. This is very important, and this is very initial aspect to have the understanding of the law of the writ, that whenever the organs of the state, including the legislative as well as the executive organs of the state, when they do not perform their duties under their regulatory laws, under the concerned statute, suppose when we speak of the legislation, legislative part of the government, that is in our country, that is a parliament in the federation, and that is a provincial assembly in the province, and if they promulgate some law which is contrary to the fundamental rights and which is contrary to the injunctions of Islam, so this is the wrong at the end of the legislation, and that wrong can be get rectified by way of invoking the judicial review of the superior judiciary. That availing of the remedy against the wrong by the legislation is called seeking a writ by the superior judiciary, and in our country that is provided under the Constitution of Islamic Republic of Pakistan, and the relevant article is 199, which provides a protection, which provides a remedy against the wrong, I mean the repugnant law promulgated by the parliament that can be called in question under the writ jurisdiction in the High Court. And simultaneously, if the executive limb of the state do some wrong, beside the regulatory regime, beside the remedies under the hierarchy of the relevant department, if at the end of the day someone feels that the organs of the state or some functionary of the state are not performing their duties in accordance with the relevant provision of that law which has been promulgated to run the affairs of the very department, in that eventuality any person aggrieved of that conduct, he also can seek the judicial review of the proceeding carried out, of the order passed, and the act or omission done by that state functionary. So this all is known in the judicial parlance. This is known as the judicial review of the acts and proceedings of the functionaries of the state, including the legislation as well as the executive or the administrative act. This concept of judicial review is as old as the judicial system. Judicial review is available in our superior judiciary in the shape of Article 199 for the high courts of the provinces, and the judicial review is available in the Supreme Court under Article 184 of the Constitution. So this power of the judicial review is there against all wrongs either done by the executive or the administrative authorities of the state, or even by the legislative of the state. The question arises that when one can choose to go for seeking the remedy under the writ jurisdiction. So before we dilate upon the very eventuality, the very relevant stage, and the very avenue when one can seek the remedy under the judicial review, under the authority of the judicial review of the High Court, we need to have a glance over the very article, since we are especially speaking here about the writ jurisdiction. Therefore, I will confine myself to the judicial review part of the judicial review available with the High Court. As far as the judicial review available with the Honorable Supreme Court is concerned, that is under Article 184. So, since we are here today discussing the writ jurisdiction that is available under the power of the judicial review available with the High Court under Article 199 of the Constitution. So, it is provided in the Constitution that the superior judiciary is the custodian of the Constitution, and it provides safeguard against the fundamental rights. Then it has been since the era and since the inception of the legal system that whenever the superior judiciary having the powers of the judicial review, whenever it is noticed by way of a formal petition brought before it that there is some transgression of authority, there is some misuse of authority, there is failure to perform the statutory duties, and there is oppressive act, there is an act of arbitrary in nature, there is some act which is colorable on the face of it, the judiciary, while exercising its power under the judicial review, come to rescue the aggrieved person under Article 199 of the Constitution. The judicial review, in fact, is aimed at to achieve the constitutionalism of the act of the executive and the legislation. So, when we keep all these aspects in view, then it would be easy to have the understanding of the Article 199 of the Constitution. This Article 199 of the Constitution is aimed at to provide a shield against the act of the state functionaries, which act is against the fundamental rights, which act tantamounts to take away or to usurp the fundamental rights, and which act is against the spirit of the Constitution, which has been provided under basically under Article 2A, whereby the objective resolution has been made substantive part of the Constitution. And of course, when we want to have the adequate oversight and we want to have a glimpse of the judicial review, and when we want to know about the limit and the scope of the writ jurisdiction, we are supposed to have a little glance over the fundamental rights, and the fundamental rights starting from Article 8 of the Constitution. This is chapter 1 of the Constitution. Say Article 8 says that whenever any legislation is made which is repugnant to the fundamental rights, which is repugnant to the injunctions of Islam, that piece of legislation can be called into question under the power of the judicial review before the superior judiciary. As I have already referred, in case it is called in question before the Supreme Court, it can be called in question under Article 184. And in case of High Court, when any piece of legislation is disputed and it is sought to be set aside, that is under Article 8 of the Constitution, whereby one can make a challenge, one can throw a challenge to the piece of legislation, pleading that this legislation abridges the fundamental rights, or this is contrary to the injunctions of Islam. This is Article 8, which prohibits the legislation, which put a clause against the legislation that no legislative authority, in case of federation, it is a parliament, it is a lower house, National Assembly, and then it is the upper house of the parliament, that is the Senate, and of course in the case of province, this is the provincial assembly. So Article 8 of the Constitution says that no law can be made against the injunctions of Islam as well as against the fundamental rights provided under this Constitution. And any person believing so that this piece of legislation has been either by the parliament or through ordinance by the president or by the governor, that can be disputed, that can be impugned, that can be challenged by way of a petition under Article 199 of the Constitution. So this portion provides under Article 8 the judicial review. That is a one kind of the judicial review which can be exercised under Article 199 of the Constitution. Step ahead, we can see that security of a person has been made inalienable rights of the person, that is provided under Article 9. Mean someone's person security to his body, to his life. This is the duty of the state to ensure the security of a person. Likewise, this security of a person is provided under Article 9. Likewise, when we see Article 10, this safeguard a person from the illegal detention and the illegal arrest. And then Article 10A, this is very important, and we each day and every occasion we read this, we invoke this Article 10A, and we emphasize on the Article 10A, and we convince the courts that such and such act is contrary to the right of individual of having a fair trial. So Article 10A is another fundamental right which provides that any person who is being accused of any mischief, he will have the right of a fair trial. He will be provided with the adequate opportunity, and the fair trial includes that he must know what sort of allegation he is being charged and what kind of evidence is being used against him. So right of fair trial includes to engage a lawyer of his own choice. So whenever this right is felt to be taken away by any functionary of the state, by any organ of the state, this can also be pressed into service by way of invoking the writ jurisdiction. And then there is a prohibition against the slavery and the forced labor, that is Article 11 of the Constitution, which provides the safeguard that any state functionary or any individual cannot make any other individual to have his labor forcibly without wages and without any remuneration. So this safeguard has been provided under Article 11. And then my colleagues, there is an Article 12 which provides a safeguard against the retrospective punishment. Retrospective punishment is a phenomena that when one cannot be given the punishment that you have been found guilty of an offence which you committed in the such and such year, though you could not be proceeded at that relevant time. So we are going to award you the punishment from today to face the music of that overt act done by you. So this article provides a safeguard against the retrospective punishment. And then fundamental rights, when we speak of the fundamental rights, then there is Article 14 which provides that a dignity of a man should always be taken care of by the state functionaries. The dignity of a man, for the simple understanding, is self-respect of one individual, a self-respect of a citizen cannot be denied on any pretext. This has been provided under the Constitution under Article 14. And then is a very important article which provides a citizen the freedom of the movement. Mean across the country, any citizen has the right to move around, starting from Peshawar to Karachi, starting from Gwadar to Jhelum, everywhere across the country. Every individual has the right to move anywhere. This right has been safeguarded under Article 15. And then is the right of assembly. Mean 1, 2, 3, 4 friends can gather anywhere. Even more, they can sit anywhere. They can have their own time. They can spend their time with their own choice. So this is a right of assembly for whatever purpose. This can be a purpose. There can be a purpose of some a political consideration of things, there can be a purpose of religious assembly. So assembling somewhere is the fundamental rights provided under the Article 16, and then is the right of association. This association right is also another important right which has been provided under the Constitution. This says that 2-3 individuals or more, they can form some association, like some welfare association, like commonly known as NGO. They can form some development organization. They even can form the political party. So this right of association has also been safeguarded by the Constitution. And then my colleagues, there is very primary right, that is right of trade and profession. Constitution says that every citizen across the country has his ample right to choose whatever trade he wants to adopt and whatever profession he wants to join. So there cannot be any compulsion on any citizen to compulsorily join some trade and to compulsorily adopt some profession. This freedom and this choice has been safeguarded under Article 18. And then is we on daily basis we come to know and we see that right of speech. Right of speech is a such right which across the globe is available in all the including the neighboring jurisdiction and all the developed countries. Right of speech is always safeguarded across the world. The right of individual to comment and to express his view and to share his thoughts, this is known as the right to speech. So right to speech is also a fundamental right safeguarded under Article 19 of the Constitution. And then is Article 19A, that is with regard to a right of individual of having the information. Mean everybody amongst us, all the individual, all the citizen has the right to know what our assembly is doing, what our senate is doing, what our chief secretary is doing, what our inspector general of police is doing, and in what manner the business of the state is being carried out. This is the right of any citizen to have the knowledge and have to have the information through official sources, that in what manner and under what provision of law and at what stage some business of the state is being carried out. This right of information is also the fundamental rights of the citizen. And then is the religious right, the right related to religion. Though this our country is a country to be known as the Islamic Republic of Pakistan, yet the right has been provided to the citizen that they can confess any religion. There is no compulsion on any individual to adopt any particular religion. One cannot be compelled to confess like Islam, one cannot be compelled to leave Christianity, one cannot be compelled to adopt Hinduism. So this is not the mandate anywhere under the Constitution that every citizen must confess Islam. So though this is Islamic state, the fundamental the concept of the running of the states are based on Islamic religion, yet this safeguards rights of the minorities who do not confess Islam and who do not join Islam, or for that matter any other religions intercede. So this is a right of the citizen to have the religion of his own choice. And then we see another important article, that is right of education and right in the religious institution. And the very important right is provided under Article 23, to have the property, to make the property and to own a property. One can has the property by way of lawful sources as much as one can. So government cannot put any embargo upon a person that you may have two buildings and you may have one house, not more than one. So one can have more than one house, more than two shops, more than 5 squares of land, there is no limitation of acquiring the property. So right of property, acquiring property and holding the property has been safeguarded under Article 23. And then there is right of the protection of the property. Like we have discussed Article 9, which is the safeguard, which is a right of, which is the obligation of the state to provide security to the life of a person. Likewise, this is the duty of the state to safeguard the property of a person. Once we see that right of the person to obtain property under Article 23, likewise there is a obligation, there is a duty of the state to safeguard the properties of its all citizens. It is duty, and it is the foremost duty of the state to protect the properties of all the individuals. Then is Article 25. We commonly term it as protection against the discrimination. So Article 25 is a right, it provides a right which is known as the right of equality, to be dealt on equal footings. No, there should be no discrimination on any pretext. Neither there should be any preference on the basis of religion, in any sphere of the state, near the citizen, on the basis of race, on the basis of language, on the basis of property. So there cannot be any discrimination amongst the citizens of the state, and this right has been safeguarded under Article 25 of the Constitution. Then is the right of individual to have access to the public places. Those are also the kind of the fundamental rights. So the salient features of the fundamental rights, when we keep all these fundamental rights in view, then the question comes that how the writ jurisdiction come into play and how one can seek the remedy under the writ jurisdiction. So the writ jurisdiction is the remedy as it is provided under Article 199, that whenever under the relevant law no other adequate remedy is provided to a person, then the aggrieved person or effectee can seek the remedy under the writ jurisdiction. So here we see the relevant text of the very provision. This says jurisdiction of the High Court under Article 199. This says that subject to the Constitution, a High Court may, if it is satisfied that no other adequate remedy is provided by the law, sub-article A, on the application of any aggrieved party, make an order. Here we take a pause that this is a very fundamental question which arises in every student of law's mind, that as to whether only the citizen of the state can invoke the remedy or any other individual can seek the remedy. This is a very important question. So the framer of the Constitution has provided, the word citizen has not been used. This is very important. Writ jurisdiction has not been limited to the citizen. This is meant for the party. This is meant for a person. So writ jurisdiction can be invoked by any foreigner as well. If some foreigner is visiting Pakistan, he feels that his right as foreigner are being abridged and the relevant law for the foreigner is being jeopardized, he can also seek the remedy. So primarily this is very important to have the understanding that writ jurisdiction and the writ petition can not only be filed and cannot only be maintained by a citizen of the state, but can also be filed by a foreigner as well. This is not limited for the citizen of the state. This can also be filed by the alien who is visiting Pakistan. Then the question comes that only as to whether the aggrieved person can only seek the remedy of the writ. This is another very important question, that if someone has a direct grievance, someone has the direct adverse effect of any act of the state, can he only bring the writ petition? The law has been interpreted, and this provision of the Constitution has been a debate amongst the higher judiciary, and the law has developed now. And as far as the aggrieved person with regard to some proceeding carried out by executive authority. In that case, to be an aggrieved person is necessary. But if someone see that if there is a matter of public importance, if there is a matter which relates to the public exchequer, which relates to the public at large, and if someone is even not directly aggrieved by some act or omission of the state functionary, so notwithstanding this very provision of aggrieved person, any person can bring the writ petition. When we file the writ petition of public interest, like we seek the remedy against some public nuisance, when we seek the direction of the High Court for some missing facility, when we seek the remedy against any legislation of the Parliament which amounts to double taxation, when we seek the remedy. So in that eventuality, the person who is bringing the writ, it is not necessary he must be directly aggrieved. He can bring the writ petition as a per bono publico. He can bring the writ petition as an actor, as a whistleblower. He can be the whistleblower, notwithstanding he is directly aggrieved from any act or omission of the state. So to be an aggrieved person directly is not necessary to bring the matter for the judicial review in the High Court. Then this article says, Article A, sub-article 1 says that on application of any aggrieved party, make an order directing a person performing with the territorial jurisdiction of the court functioning in connection with the affairs of the federation or a province or a local authority to refrain from doing anything he is not permitted by law to do, or to do anything he is required by law to do. So when we want to know the kind of the writs, the first one writ which has been provided under Article 199 sub-article 1A. So this is a kind of the writ which High Court can issue, that is multifold, that has twofold. This same time is this Article 199 sub-article 1A is writ petition is of twofold. One is of prohibition and the other is of mandamus. Prohibition part of writ says that if someone comes to High Court that Mr. A, who is a state functionary, who is going to act contrary to such and such law, and he is not having such authority to act in this regard. So if one comes to the court that he be stopped from doing so, so this would be a writ of prohibition, and this would be a writ under Article 199 sub-article 1A. And the second portion of this sub-article A says that if someone is supposed to perform his duties, but he is failing to perform his duties, and he is obliged to act in a particular manner, but he is not acting in that particular manner, then the aggrieved person may come to the High Court and can seek the remedy against that particular individual or particular functionary of the state. He can look for the appropriate order, and when High Court directs some functionary of the state, Mr. So and so, you are directed to act in accordance with such and such provision of law. So this is a kind of the writ which is a mandamus in nature. For an example, each day we go to the High Court and there are number of the writ petitions which are filed that I have made an application to such department seeking some relief, but my application is pending. My application is pending with him since so many days, and that is not being decided. So this, when we seek a direction to that functionary to decide our pending application, the fundamental question arises, under what law he is supposed to decide our application. So notwithstanding the very provision under the regulatory law, the general law, that is the General Clauses Act, and the section 24 says that state functionaries are supposed to decide the list pending with them judiciously and expeditiously. So whenever we go to the High Court that my application is pending before the Chief Secretary, my application is pending for the Secretary Education, my application is pending for the Secretary Health. So when we seek the direction to get our application decided, we seek the remedy of writ of Mandamus, which is provided under Article 199(1)(a) of the Constitution. So the kind of writ which comes first in number, that is writ of Mandamus and writ of Prohibition. This both writ petitions, both writs, the kind of writ are embodied under the same article, but the rest of the kind of the writs are separately dealt under the further articles. So we have now shared the kind of the writ known as writ of Prohibition and writ of Mandamus. Prohibition can be sought against any state functionary not to do any act for which he is not authorized under the law, and the Mandamus is a writ when we seek the remedy by requesting making the prayer to the High Court that such and such state functionary be directed to act in accordance with law and to perform his duties under law and to decide the matter in accordance with law. So the next question comes that with regard to Article 199(a)(2). Here this is another important kind of the writ. This writ is commonly known the writ of Certiorari, and this says that the High Court may direct declaring that any act done or proceeding taken with the territorial jurisdiction of the court by a person performing functions in connection with the affairs of the federation, province or the local authority has been done or taken without lawful authority and it is of no legal effect. Each day when we are sitting in the High Court, when we are sharing things with our colleagues, we see there are the number of the writ petitions which are filed against the MBR, against the Judge Family Court, against the Punjab Labour Appellate Tribunal, against various other state functionaries. And what kind of writ we seek? The writ we seek is that the order passed by that authority, by that Judge Family Court, or by that top person in the hierarchy of the revenue are against the law, and the order passed and the proceeding carried out are ultra vires, are not in accordance with the fundamental rights and not in accordance with the Article 10(a), so and so more. And when we seek the setting aside of some order of the state functionary, we seek a writ of certiorari. The writ of certiorari is known to be exercised against any order passed by the state functionary which is against law, which is without jurisdiction, which order is without lawful authority, which does not come to the standards, come to the canons of the justice. So whenever we seek the setting aside of some order in High Court, we seek a writ of certiorari. And this certiorari writ petition has a vast impression and has a vast impact. All orders arising out of the final forums of the regulatory laws, because otherwise, suppose if someone says I am going to challenge the order of the district collector appointing any person as a nambardar of the state, so he can straight away come to the High Court? No, he cannot come directly to the High Court seeking the writ of certiorari, because there is an alternative remedy of filing an appeal before the commissioner and then filing a revision before the member board of revenue. So end of the day, we are supposed to challenge the final order of the concerned hierarchy, and we can ask the Honorable High Court that this final order of the revenue hierarchy and this final order of the whatever regulatory regime that is against the fundamental rights, that is against the recognized principle of law. So writ of certiorari can be brought in High Court seeking setting aside of the order of the various organs of the state, including the judicial forum, because suppose in rent laws there is no remedy against the interim order. Suppose in family laws there is no appeal against the degree of dissolution of marriage on the option of puberty. But when there is a case of somebody that the order has been passed against the fundamental principle of justice, he can file the writ petition. So writ petition filed to seek setting aside of the order of any organ of the state, any judicial forum of the state, that has been stated to be passed against the canons of justice that covers, that comes and that fall within the ambit of writ of certiorari. And then we come to the writ of Mandamus, writ of Quo-Warranto. This writ of Quo-Warranto is provided under Article 199, sub-article 1B. This says, High Court on the application of any person make an order directing any person, Article 1A, B2. This is with regard to the Quo-Warranto, requiring a person within the territorial jurisdiction of court holding or purporting to hold a public office to show under what authority of law he is claiming to hold the office. So this says that any individual believing that Mr. A sitting as chairman of the MDA or suppose sitting as the MD of the VASA was not legally entitled to hold that office, but he has been put to that office through some backdoor process, and he has been made to sit in that office flouting the law and bypassing the principle of meritocracy. So one can seek the remedy under this sub-article, asking High Court to issue the writ that this person does not possess the threshold, does not come to the merits to hold this position. And when this writ petition is sought, this writ petition, the kind of writ petition is known as the writ of Quo-Warranto. And in the kind of writ petition as Quo-Warranto, we may have the examples in appointment of chairman PIA, in case of appointment of the chairman PTA, the writs of Quo-Warranto were issued, and the appointment of chairman PTV case, we can refer the chairman PTV case, where the person were appointed with heavy remuneration but not having the requisite qualification to be appointed for those posts. Those appointments were set aside under the writ jurisdiction under Article 1B2 of the Constitution. So this kind of the writ petition is known as the writ of Quo-Warranto, whereby High Court can direct any person to show under what authority of law he is sitting in that office. So this is a writ known as writ of Quo-Warranto, and then is the writ which is defined under Article 1B1, that the territorial that on the application of a person making an order directing the person in custody within the territorial jurisdiction of the High Court to be brought before it, so that the court may satisfy itself that he is not being held in custody without lawful authority. This writ, the kind of writ, is known as the writ of habeas. Very commonly, we each day see, we each day file, and we come across the writ petition where the petitioner says that his brother, his son, his friend has been kept in legal custody by the police, and there is no criminal case registered against him. And when this story is brought before the High Court, and the High Court asks, suppose, concerned CPO, concerned SHO to produce a person, and if the person is produced and no criminal case stands registered against him, the High Court order to set him as liberty. So this power of the High Court, while exercising this power, the High Court issues the writ of habeas in nature. So these are the kinds of the writ which have been provided under the Article 199. Summarily, we repeat: this is the writ of writ of Quo-Warranto, writ of Prohibition, and writ of Mandamus, and writ of Certiorari, and the writ of habeas. So the question comes that as to whether there is some rider and there is any some condition on filing the writ petition. So the primary answer is yes. There are so many conditions and so many riders and so many obstacles when one has to maintain the writ petition. There are so many conditions in this regard. The conditions are: suppose though no limitation is provided for bringing the writ petition, yet the writ petition is to pass the test of not being hit by the laches. Laches is a term, is a Latin term which says that an aggrieved person must not be indolent, and he must not be having a deep slumber, and he must not be having so invigilant about his rights. So notwithstanding the fact that there is no limitation provided under the constitution to file the writ petition, yet there is a clog, yet there is a barrier for the individual to maintain a writ petition, that it should not be hit by the principle of laches. So it should not be badly time barred, it should not be badly viewed as the indolent act on the part of individual. And what other impediment which has to be crossed by the litigant is that if he is seeking the remedy, the court must have the territorial jurisdiction into the matter. Like if Mr. A is abducted and kept by the police station at Sibi, Balochistan, and he was arrested there and he was detained there, but I am seeking the remedy by way of writ petition for issuing of the writ petition here at Multan, so I may not have the remedy because Lahore High Court has not jurisdiction to issue the writ of habeas against the jurisdiction where the mischief has committed, where the illegality has been committed, where the individual has been kept into the illegal custody within the jurisdiction of Balochistan High Court. So this is another condition upon a litigant, upon the one who maintains the writ petition, that he is supposed to establish that the High Court concerned has the jurisdiction in that regard. And another clog and another rider which is very important and which each individual has to cross while maintaining the writ petition is that he has to demonstrate that no other adequate remedy is available under the law. Because like I have already referred in case of writ of certiorari, that a person bringing the writ petition must establish that no adequate remedy under the law is available, and there is an imminent danger, there is a threat to the abridgment of his rights, and even if there is some remedy available under the law, that is not speedy and that is not expeditious. So one has to establish and one has to demonstrate that he is not going to avail that remedy, either that is not efficacious or that is not speedy, or he has availed the remedies. And one cannot bypass the relevant law of the regime. Like one is seeking the allotment of the state land under the Colonization of the Government Lands Act 1912, and he make an application that I am entitled to this half square of land for allotment for a temporary cultivation, and if DC declines, one cannot straight away come to the High Court. He is supposed to make the appeal before the commissioner and then to seek the remedy before the Board of Revenue of Revision. So one is supposed to demonstrate, is supposed to establish that no other adequate remedy is available to him. So this is another clog and this is another impediment in way of the litigant, that he is supposed to cross that barrier. And what other barrier? That is the bona fides, that is the locus standi. Locus standi and the bona fides are very important to establish, to seek the writ and to seek the remedy under the writ. So if the court feels that the writ petitioner is habitual, if the courts observe that the writ petition has been brought for the ulterior consideration, so writ jurisdiction and exercising writ jurisdiction and awarding relief under the writ jurisdiction, this is a discretionary relief, and the one who is seeking the relief under the writ jurisdiction, he must demonstrate equity at his end, he must have the fair play at his end, he must not be with the unfair play, and he must not be unclean-handed with unclean-handedness. So this is very important rider against the one who wants to maintain the writ petition, that he must establish that he is with clean hands, he is having the locus standi, and he is aggrieved person. But I have already referred that in case of writ of Mandamus, in case of writ of certiorari, as far as the legislative piece of legislation is concerned, directly to be aggrieved person is not necessary. There are the judgments I will be quoting in this regard. that to be an aggrieved person in that case is not necessary. So another question comes that under what procedure this writ petition is filed. So this is very primary question. Most of us know that writ petition is filed and proceeded under the CPC, because the Constitution has provided that all the High Court may frame their rules for the effective performance and for the exercising of their jurisdiction. So under High Court rules and order, the writ petition is proceeded as the proceedings of the under the CPC. So like we see that whenever we file some miscellaneous application in the writ petition, we file an application under 151 CPC seeking some ancillary relief. Like if we want to amend the writ petition, we same time file the same application for amendment as we file the amendment application for amendment of the plaint. Likewise, if we want to implead someone as a party to the writ petition, we file the same application under order 1 Rule 10 CPC. Like the writ petition is dismissed in default, for the restoration of the writ petition, we file an application under the CPC. So the procedure of the writ petition is regulated by the CPC. Code of Civil Procedure is the regulator for the purpose of proceedings of the writ petition. And the then question comes that against which state functionaries writ petition absolutely cannot be maintained. This is very important question, and the very learned law officers are here. So there are certain constitutional exclusion, like no writ petition can be maintained against the president of the state, no writ petition can be maintained against the prime minister, against the governor, against the chief minister and the sitting minister of the state. No writ petition. I will be quoting the relevant article in this regard. No one can maintain the writ petition straight away impleading president, governor, the chief minister, the minister of the state, seeking some directly remedy against them. So this is very important, that this again is an exclusion from the writ jurisdiction. And then even under Article 199, there is a very important exclusion, that is under sub-article 2, that no writ petition can be filed and can be instituted seeking some act against the functionaries of the armed forces. The armed forces functionaries, while performing their duties in connection with their sphere, that cannot be called in question through the writ petition. So against the armed forces like army, like navy, like air force, we cannot file the writ petition against their own functions, intercede their department, intercede their employees, intercede their officers, intercede their policies. We cannot seek the writ. This is the exclusion of the writ petition, which is provided under Article 199. And then question comes that even under Article 199, the writ of certiorari can be maintained against a policy matter. The answer is no. The general policy is, the general law is that when there is a policy being framed by the government, when there is a some plan is being set into motion, that cannot be called in question under the jurisdiction, and the policy matter of the government is the prerogative of the government, and that is the fundamental principle, that policy matter cannot be called into question in the writ jurisdiction, and only policy matter if it is violative at the touchstone of the fundamental rights. Only in that eventuality that can be called in question. So making the policy, like if the government says the government is going to establish a road from Multan to Sakhar, so one cannot say why this road is being made. This is for the government to make the policy, and this is for the government to establish the roads. Government can build the roads, government can make the provisions for in the way it feels appropriate. And then the question comes that as to whether simpliciter impleading some government functionary writ petition can be maintained. This is very important, sir, that writ petition cannot be maintained against the federal government functionaries unless the federation is made party. This is very important. In case we are seeking the relief against the functionaries of the federal government, we are bound by law to implead the federal government as a party. And when we are seeking the remedy against the provincial government, we are not solicitors to implead only that particular function. Like if we are aggrieved by the act of Secretary Health, we are just filing the writ petition while making Secretary Health as respondent. No, the law says that the litigant or the writ petitioner is supposed to implead the province of the Punjab as a party to the writ petition, or in case the federal government functionary, the Federation of the Pakistan is a necessary party to the petition. So unless the Federation is made party in case of federal functionaries, and unless the province is made party in case of the provincial government functionaries, the writ petition cannot be maintained. And then is that as to whether High Court has the unfettered powers to pass any kind of interim order, any kind of restraining order. So the primary answer is no. The Article 199 says that unless and until the law officer has not been put into notice, the law officer has not been given the notice, High Court cannot pass order restraining the state functionaries to act in a particular manner. So notice to the law officer concerned is a mandatory. Straight away High Court cannot pass, and that's why we usually see whenever we seek some remedy of interim relief, Honorable Court used to call the law officer. That is for ourselves to give them the notice. That is the mandatory provision to giving notice under the Article 199 itself, and straight away passing order by the High Court without putting notice to the provincial government or for that matter the federal government, that is unconstitutional. And another question is that if the High Court passes any order that is interlocutory in nature, whereby collection of some revenue has been stopped, whereby recovery of some cess has been restrained, or even for that matter state functioning has been stopped, like some recruitment process has been stopped, can that order remain in field? Can that order hold the field for all the times to come? No. This is very important. The Article 199 sub-article 2 says that the High Court's order, which is interlocutory in nature, restraining the state functionary, stopping the recovery of some revenue, taking some measure of punitive in nature, that cannot hold field beyond 6 months, and after 6 months that automatically lapse. So that order of the High Court restraining the state functionaries lapse after 6 months. So this is the general edifice of the writ jurisdiction. And so far as if my learned, any of my learned colleague wants to have a note of the judgments in this regard, with regard to the writ of Mandamus, writ of Certiorari, writ of Habeas, and writ of Quo-Warranto, I can refer the judgments in this regard. And very important that this kind of writ petition, the word writ has not been used in Article 199, though it was used in the Constitution of 1952 and 1956 and 1962. The word writ was used, but in Article 199 the word writ has not been used, the word order has been used. But in common parlance, this is a writ for all practical purposes, as the writ jurisdiction is being exercised in the adjoining jurisdiction in India's constitution. This writ jurisdiction in India's constitution, this is provided under Article 2 to 6 of the Constitution of India. Likewise, though the Constitution of United Kingdom is not in the written form, yet there are certain pieces of legislation which, including the Magna Carta, including the Charter of Fundamental Rights. So Article 124 of the UK's constitution provides the same powers to the Constitutional Court of the UK, whereby Constitutional Court of the UK can exercise the same power. Likewise, under the Constitution of United States of America, this power is provided in Chapter 10 of the US Constitution of 1787. So synonymous and so the similar and the paramateria provision are available in the adjoining jurisdiction as well as in the jurisdiction of UK and the USA, where same kind of powers for judicial review are exercised. And so far as the judgments in this regard are concerned, may I refer that the writ petition can be maintained even during the pendency of the civil suit. This is very important. If any of my learned colleague want to have a note of it, writ petition can be filed even the suits are pending inter the parties, but there is some oppressive act, there is some act which abridges the fundamental rights. PLD 1988 Supreme Court page 30, CLC 2008 page 102, PLJ 2000 Lahore page 1801 and PLD 1971 Supreme Court page 130. These judgments says that even inter the parties there are civil nature dispute, yet the party can maintain a writ petition. Then very important aspect is that the question always arises as to whether the writ petition is maintained, can be maintained only against the state functionary. General answer is yes, but there is an exception. There is a judgment of the High Court that and as well as of the Supreme Court that writ petition can be maintained against a private individual as well. May I take your attention while referring to PLD 2010 Lahore page 23. In this case, the writ petition was issued against a private individual, and PLD 2009 Supreme Court page 507. In this case, the court observed that the writ petition can be maintained against the private individual as well. And then is the judgment with regard to policy decision. As I have already referred that the policy decision cannot be called in question in the writ jurisdiction, but there are exceptions in this regard, and exception has been stated in the judgments that those are the judgments like 2011 Supreme Court monthly review page is 1621, and another judgment in this regard is 2011 Supreme Court page 1743. And then is that as to whether the civil servant can maintain the writ petition, the answer is no. Civil servant having the terms and condition of service under the statutory law cannot maintain the writ petition regarding his terms and condition of service. This prohibition has been provided under Article 212 of the Constitution. Whenever we take the writ petition of a civil servant to the High Court refrains itself from passing any order because there is an impediment on High Court. There is a bar of the jurisdiction under Article 212, but there are certain judgments where the High Court and the Honorable Supreme Court has said that notwithstanding the bar of Article 212, High Court can pass order even in case of the civil servant, and those judgments, may I take the privilege to refer those judgments. Those judgments are this is Tariq Azizuddin case 2015 SCMR page 253, then is 2010 SCMR page 1301, and very famous case Shariar. This is Zahid Akhtar's case PLD 95 Supreme Court page 530, and then is this is the case of Mahmood Akhtar Naqvi. This is 2013 Supreme Court monthly review page 195. These are the exceptions to the Article 212 stated by the High Court that in some exceptional cases High Court and the Supreme Court can pass some orders even in the presence of the bar of jurisdiction. Then is with regard to the judgments with regard to the laches. The principle of laches, though come in the way of the litigant, yet there are exceptions to the principle of laches, and both judgments I will be quoting. These are 2005 Supreme Court monthly review page 126, 2012 Supreme Court monthly review page 280, PLC CS Supreme Court page 218, and 2012 SCMR page 1004. As I have referred that unless the law officer is not put to notice, High Court cannot pass any interlocutory order restraining the state functionary to pass some order. This is section 27. Putting the state law officer to the notice is mandatory for passing any interlocutory order against the state functionary. This is section with regard to the constitutional issue. When one varies of some piece of legislation, some notification is called in question, section 27A of the CPC mandates High Court will issue notice to the Advocate General, and then will pass referring to the protection of writ petition against the constitutional post. That article is 248. 248 article prohibits that no petition can be made against the President, against the Prime Minister or other constitutional functionary. This is article 248, and then I for your sharing refer the judgments that factual controversy cannot be resolved in the jurisdiction. There are the judgments on both sides. I will be referring both side judgments. For the limited purpose, High Court can go into the factual controversy, but general principle is that High Court cannot go, but exception has been stated in these judgments, and these judgments are 2015 Supreme Court Monthly Review, page 595, and then is 2011 Supreme Court Monthly Review, page 279, and 2011 Supreme Court Monthly Review, page 1990. And then the judgments, as I have stated, that when the alternative remedy is available, writ petition cannot be maintained, but exception to this principle to have been given by the superior judiciary. In this regard, the judgments of the apex court can be referred. Those are 2012 Supreme Court Monthly Review, page 455. These judgments says that even in the presence of the alternate remedy, writ petition can be maintained. This is PLD 2010 Supreme Court 969, PLD 2008 Supreme Court, page 135, 2001 Supreme Court Monthly Review, page 1493. And the judgment which prohibits the unclean hand person to maintain the writ petition, that in that regard is 2011 Supreme Court Monthly Review, and likewise the judgments of the Honorable Supreme Court that to maintain a writ petition of public interest, aggrieved party to be an aggrieved person is not necessary. In that regard, I will be referring to Darshan Masih case, and the number of the this is Dungi Ground case, Steel Mills case, Golf Course case. In those cases, the question arose, the person who was held that though the general principle is that aggrieved person can maintain writ petition, yet when there is a matter of public importance, when the matter relates to the public exchequer, when some citizen of the state feels that his tax, being the taxpayer money, his money is going to be wasted by way of some act of the functionary, he can maintain the writ petition, and that writ petition is maintained under the principle of pro bono publico. And in that regard, the judgments are PLD 90 Supreme Court, page 513, and NLR 2006 Supreme Court judgment, page 732, and then is the renowned case of writ of Certiorari regarding the act of contempt of court promulgated, challenged by Baz Muhammad Kakad. In that case, the Honorable Supreme Court set aside that act of contempt of court promulgated by the then governmental regime, and in that case it was also held that it was not necessary for the one who maintained the writ petition that he must be the aggrieved person, and that piece of legislation was set aside, holding that the writ petition in that case the writ petition was not, it was the petition under Article 184 before the Supreme Court, and Baz Muhammad Kakad was held to have validly assailed the constitutionality of that piece of legislation. And then I will be quoting, and that Baz Muhammad Kakad's case is PLD 2012 Supreme Court, page 293. And as far as the exception of maintaining a writ petition against the armed forces is concerned, though the general principle is that no writ petition can be maintained against the armed forces personnel, but there is an exception that has been stated in the judgment reported as 2012 Supreme Court Monthly Review, page 1229. So I have tried to comprehend the overall scheme of the writ jurisdiction and the kinds of the writ jurisdiction and the preconditions to maintain the writ petition, some riders and some restriction on the writ petitioner to maintain the writ petition, and where the jurisdiction by the High Court can be abdicated to exercise under Article 199, and the do's and the don'ts have been defined in the Article 199 itself. So if any of my colleague has some question, I am here to reply. Thank you very much, sir. Sir, thank you very much, sir. बहुत शुक्रिया सर. मैं again my vote of thanks to the Honorable President Mohammad Imran Khakbani and Sayyid Arif Hussain Shah, the Secretary, and especially my thanks to the Sarf and Qureshi who all the way arranged this gathering and invited me to express my view. Thank you so very much.